I'm Rebecca Seitz, and this is Right to Life. Welcome to the 7th episode of this journey we're on to chase wisdom and get understanding regarding the issue of abortion. Since starting this journey, I've received feedback that runs the gamut from gratitude for creating a space devoid of politics to talk about this issue, all the way to words of condemnation, because I'm not towing a political or a denominational party line. You can probably imagine some of what those responses have looked like. But at the end of the day, what matters to me, what I want to live my life in accordance with, is truth. I find safety, security, and peace in truth. And so every time I encounter a point for or against Amendment 4, I research it. And today, you get to hear how I research things. Namely, I go to the people who have the information and education to answer the questions truthfully. So today I welcomed attorney James Chilemmi, who himself is not affiliated with either the Republican or Democrat parties, back into the 1C studio to specifically address the talking points of those who are encouraging people to vote no on Amendment 4. Let's see what truth we can find. Come, let us reason together. James Chilemmi, welcome back to the Right to Life show.
Thank you so much for having me.
I appreciate you coming back here because some questions keep coming up for us, and I thought, I need a legal mind, and that's not me, but I do know who has
Don't
one.
sell yourself short.
So I thought, let me see if he could come back in here. So I really appreciate you taking the time.
Of course.
One of the things that has come up, one of the questions that has come up is this term that's in the amendment. Of course, the amendment itself is 2 sentences, and one of the terms that is used in it is healthcare provider. And one of the objections that I've been hearing is that that term is not defined in the amendment, and so it could mean the receptionist at a Planned Parenthood calling themselves your healthcare provider and saying that it's fine for you to get an abortion. And so I wondered, is that a defined term in Florida law somewhere, or is it truly just not defined?
So I think you hit the nail on the head with this one. A lot of pushback has been to the fact that it does not say doctor, it does not say physician, it says healthcare provider. And more so than that, some of the adversarial, some of the stuff that's out there right now that's on the adversarial side is saying that that is purposefully done, that the reason why a healthcare provider and not doctors put in there is because they want it to be, like we talked about last time, ambiguous. However, in this case, I don't believe it is ambiguous. I think once there is a defined definition in the Florida statutes, which there is for healthcare provider, it can't go above and beyond what's in that definitional section. And so if we look at what a healthcare provider is, it's someone who's licensed to perform abortions.
Licensed by the state?
Correct. So in terms of who has licensure to perform abortions, the only people in the state of Florida who have license to perform abortions are doctors. And most of the time, they're board certified. So it couldn't be any clearer. I guess you have to kind of have an understanding or background in this to understand that this is already defined and that a doctor is the only person under this provision that would be able to perform an abortion.
And would a doctor be the only one that could prescribe the abortion?
As far as I know, it would have to be somebody who has the license to do so, and the only person that could do that would be someone who has the medical license in order to do that. And so that would be the physician, and like I said before, most of the time these are extremely accomplished board-certified physicians. So
do you know in what section of Florida law they define healthcare provider?
I thought you might ask that, and so...
I love that you can anticipate.
No, so section, I mean, there's several sections, obviously, that mention healthcare provider. I believe the one that would be most applicable to what we're talking about would be Section 381.026, which is the Florida Patients' Bill of Rights and Responsibilities. And so, as the Florida Patients' Bill of Rights and Responsibilities, you can imagine this is a very germane statute in defining several of these terms. And Section C of subsection 1 is healthcare provider. Means a physician licensed under Chapter 458, an osteopathic physician licensed under 459, a podiatric physician licensed under 461, or an advanced practice registered nurse registered under 464. Now, as far as I know, I'm not necessarily sure. Again, not an expert on abortion, not an expert on the procedures, don't really have that much of a learned understanding to opine on it. I'm not sure if a registered nurse would be licensed to perform an abortion. However, I do know that when abortions are performed, they do require licensure, and that licensure is that of a physician.
So unless you have, let me make sure I understand what you're saying, unless the state has licensed you to be a healthcare provider, you are not a healthcare provider, so as it's used in this amendment.
Correct. That's the way I understand it.
Okay, so it couldn't be the receptionist at a clinic or somebody who just hung out a shingle and called themselves a life coach or whatever. Not that there's anything wrong with life coaches. I'm just saying that's what I've been hearing from the Vote No crowd, is that it could be anybody who says, I'm here to help you with the health of your life in some way, shape, form, or fashion. And what you're saying is, no, they would have to be licensed by the state as a healthcare provider.
Correct. And when I was watching some of the material that was pushing back against this amendment, I heard someone say that a massage therapist would be able to perform an abortion. And I can't think of anything more asinine, that this is the misinformation that's being pushed out, or that a tattoo artist or somebody that would have any sort of tangential association to healthcare or looking after your health. It makes no sense. And if you look through the bevy of case law, but also the Florida statutes, I don't think it could be any clearer.
Okay, good. So we don't have to worry that healthcare provider is not a defined term. It isn't that it's defined in the amendment, it's that it's an already defined term in Florida law.
Correct.
So they didn't have to say that entire definition over again.
100%. It's what's called codified. Healthcare provider is codified into law at this point. And so when you look at that, right, this is part of our job, is when we see certain things as lawyers, especially when we're trying to prove a case one way or the other, is to what does that mean? And in the applicable realm of what we're talking about, healthcare provider couldn't be any clearer.
Okay. So one of the other words that I've heard be questioned, that I think we covered this with our previous episode with Dr. Brothers, was that word viability. And she did let us know that viability is around 22 to 24 weeks as determined by the physician. It's different with every pregnancy to pregnancy, but it's around 22 to 24 weeks. And that leads me to the next question that I'm getting, because, our listeners, most of our listeners, I think, have my background of coming from an anti-abortion, pro-life community. And so a lot of us, we're encountering this kind of information for the first time, or maybe the first few times. And so there's a lot of wrapping your mind around this kind of information and how it jives and squares with what you've already been taught. And so one of the concerns that I have gotten from my pro-life anti-abortion community is that this amendment allows for late-term abortions. Does it allow for late-term abortions? Because when I read the amendment, this one struck me as that can't be right, because it says up to the point of fetal viability is determined by a healthcare provider. So if fetal viability is 22 to 24 weeks, according to an OBGYN, then is there a way that this amendment would allow for late-term abortions?
No. The answer simply is no. What this amendment, what the effect of passing this amendment and enshrining it into the Florida Constitution would do is return us to something more similar to the protections codified by Roe v. Wade. And what happened there was they were protecting women's rights to an abortion and their bodily autonomous rights to an abortion before fetal viability. But like you just said, no, this would not allow for late-term abortions. It would have to be up until the point of fetal viability, which, as we now understand it, generally is 22 to 24 weeks.
Got it. Okay, so that is not something that we need to be concerned about, that if we vote yes on this amendment, we're allowing abortions to happen in the 39th week or up to the point of birth.
Correct.
Got it. Okay, good. And then another thing, good in that I'm happy to hear that is what I mean good.
Sure.
Because the way that Dr. Brothers explained late-term abortions to us, those, first of all, they're incredibly rare. Most women who need access to abortion at that phase of a pregnancy have planned to have that child. They have a nursery ready. They have a name picked out, monogrammed blankets, and they've had showers, and something has gone horribly awry in the pregnancy. And they know that this child is not going to be viable at that point because something has gone wrong. And so rather than force a woman to give birth to a child that is going to either die during the birth or shortly thereafter, the woman is allowed to terminate the pregnancy early. The woman is offered the ability to terminate the pregnancy early rather than continue with that 1, 2, 3 weeks, whatever it is.
That was my understanding as well. When you look into any time that a late-term abortion is, whenever someone especially wants to talk about it, it's usually a horror story that they tell. Mm-hmm. And so, yeah, as you can imagine, that is not something that the law wishes to put front and center is late-term abortions and codify protection for late-term abortions. But just like you said, sometimes, and as each pregnancy is different, sometimes there are exceptions to the rule.
Got it. Okay, so but there aren't any exceptions in this amendment. This amendment is up to the point of fetal viability. Or I guess if the mom's going to die, but that's a whole other situation.
Right, with medical emergencies. So again, your licensed healthcare provider, mm-hmm. and AKA your doctor, mm-hmm. would have to make that decision.
Okay.
And again, like we spoke about in our previous episode, under penalties of law, under criminal penalties. So if they do make the wrong decision, if it is deemed by a court or by a prosecutor that it wasn't an emergency, that this was just somebody who forgot that they had a fetus inside of them.
Until 38 weeks and decided I should do something
again,
about this.
The onus is going to be on the doctor, because we have to remember there are no criminal penalties enshrined in law for the woman.
Just for the doctor.
Just for the doctor. So, and like we spoke about before, it gives the doctors pause, whether we believe that's a good thing, a bad thing, or what have you. Mm-hmm. It is a deterrent for making willy-nilly decisions, that this is a very serious decision anytime a doctor has to go one way or the other.
Mm-hmm, mm-hmm. I spoke with a woman today who works with patients, and she said, she's not a doctor, but she works with patients, and she told me the story of a woman who ultimately had to go out of the state to get health care. And we talked about how, that is still an option, right? You can leave the state if you have the wherewithal to do so, and you can go to another state where abortion is allowed. But I thought about it when she was telling me about that patient's story, and it happened a long, long time ago. And the patient ended up telling her own story to the media, so it's out there and it's public knowledge. But I just sat and thought about how much more difficult that must have been, that now you have to make it a whole trip, and all the expense of a trip somewhere, and to go get your health care that you needed because we didn't have it. And so, I don't know, it seems like we're making life harder for a woman at a time when I would like for that to not happen.
Well, I hear you.
For it to not be harder for us to live and to live our lives. But
the good news is, or I should say, the good news to your point, if this is something you're concerned about, which I know a lot of women are, and a lot of people are, mm-hmm. On both sides. I believe there are 15 states that on election day, and when we have to go vote, are proposing similar amendments to protect protect a woman's bodily autonomy up until the point of fetal viability.
Got it. Okay, two more things. One, there's a concern out there that's been voiced to me, and that I think is on one of the Vote No websites somewhere, that says if we pass this amendment, taxpayers will have to pay for abortions. Is there anything in the two sentences of this amendment that says taxpayers are going to have to pay for abortions? I have not read that, but I thought, is it in there and I'm missing it?
No, I think this is This is a talking point, again, of misinformation. And there is a ton of misinformation that is swirling around this amendment and the passing of it. I don't know where that comes from. I guess if you wanted to say that if you had a medical facility that did receive government subsidies and were performing abortions, that somehow you could draw a crooked line of causation between those. But in terms of direct taxpayer funding for this, there's nothing I've seen.
It's not in there.
Yeah.
Okay, the final thing I want to ask you about, and this one comes up a lot. It has come up a lot with our listeners. I have been asked about it a lot, and I have said I am not an attorney. This is my understanding, but I'm having our attorney back on to answer this. So, with regard to parental notification and parental permission for minors who are seeking abortions, my understanding is that current Florida law does now, and pretty much has always, required parents to provide permission for minors to receive abortions. This amendment, I do not read anything in this amendment that is attempting to nullify that already in place provision where parents have to give their permission before a minor can access abortion. Is that still the case? Does this amendment change that?
So no, it doesn't, because there is a constitutional provision as well as in the bill itself, in the amendment itself, says this amendment does not change the legislature's constitutional authority to require notification to a parent or guardian before a minor has an abortion. That language is in there. Also, there's Florida law and Florida constitutional law that requires both notification and consent. So
I don't want to run past that, because that's what I found out, is that there are only 6 states in the entire nation that require what you just said, both notification and parental consent, and Florida is one of them, right?
Correct.
And that doesn't change.
This is the funny part, Rebecca, is that this happened in 2020. That when Roe v. Wade was overturned and the 15-week abortion ban went into place, that law went into place with it, the notification and consent. That's when we got it. So people that I hear bemoaning and that are terrified that the fact that now there is even a small chance, let's call it, a small chance that parental notification or parental consent will be done away with. Well, where were you the last 31 years before 2020 when there was no parental notification or consent required? Mm-hmm. I mean, 1989 was the last time that anything like this was even in law. So from 1989 till 2020, there was no notification or consent required. There is now, and this amendment protects it.
This amendment protects that the parent still must be notified, and it does not get rid of the existing law that the parent must provide permission.
The Supreme Court of Florida has issued a very clear opinion that parental notification and consent are required. Now, what I think our governor is perhaps concerned about, perhaps it's political talking points, perhaps it's deeply held Catholic belief, I'm not sure one way or the other. But what I can say is what he potentially, and what people like him in their opinions are afraid of, is that these laws will then be challenged. Once this amendment passes, they will try to say that, similar to Roe v. Wade, the parental notification and consent are now an infringement upon the minor's rights.
But that would be a whole separate issue from this amendment if that were to happen.
A case would have to come first in the trial court, then to the appellate court, and then it would have to be certified to the Supreme Court. The Supreme Court would then have to, and the Supreme Court in the state of Florida, as we all know, is more conservative, at least how it's currently situated. Mm-hmm. The idea, in my legal opinion, the idea that the Florida Supreme Court as it currently stands would overturn the parental notification and consent law, I think is dubious at best.
Okay, so just to reiterate, this amendment, as it is written, of what we are voting for or against on November 5th, what we are voting about, I guess is a better word, on November 5th, this amendment does not get rid of the requirement to notify parents and that the parent must give consent for the abortion for a minor.
Correct. That notification and consent is codified constitutionally in Florida law right now.
Got it. Okay. I asked someone on the Yes on 4 side to explain to me, if it doesn't affect it, why is this sentence here? Because it is a little confusing. The amendment itself is 2 sentences, and the second sentence is the one that you just read, where the amendment says this doesn't do anything to the current law about parental notification. And she explained to me that when you submit an amendment to the state constitution, your amendment can only do one thing. You cannot try to get 5 things accomplished in one amendment, that your amendment has to be singularly focused. And so they had to make it clear that they were not trying to affect parental notification and parental consent with this amendment. They had to make that clear so that if the question arose of, are you also trying to get rid of parental notification and consent, that the sentence would be there and be clear that no, that's not what this amendment is about. This amendment is singularly focused with enshrining the right to abortion up to the point of fetal viability as determined by a healthcare practitioner. So that part made sense to me. But if you don't know that, I didn't know that. I didn't know you can only do one thing at a time in a constitutional amendment.
No, I hear you.
And I thought that's an easy point to get confused about of, well, if you're not trying to change parental consent, parental notification, why is it there? Oh, it's there because you're trying to make it clear that you are not attempting to impact that law with this amendment. That, what did you call it? Codified, what did you?
Constitutional protection.
Constitutional protections. So, just to recap, healthcare provider is a defined term.
Correct.
It requires licensure by the state.
Correct.
Already. This amendment doesn't get rid of that, right?
Correct.
Parental notification is already required by the state. This amendment doesn't get rid of that.
Correct.
Parental permission is already required by the state, and this amendment does not get rid of that.
And like you spoke about, I think they're completely bifurcated issues. I don't think they're associated. It's not like when you pass a statute. When you pass Florida law and they have congressional session and it goes through both chambers and it's passed into law by the governor or vetoed by the governor, what a lot of times senators and congressmen will try to do is add what's called pork into the bill. And so they'll say it's a bill to protect the lives of the homeless, and they'll put something in there about subsidizing oil tankers off the coast. So
that helps the homeless.
Exactly. And so what we try to do with the constitutional amendments or anything that is as sacrosanct as the Constitution in the state of Florida is, you're 100% correct. It's a one issue. There's no pork, there are no earmarks, there are no kickbacks. This is a single issue that we have a supermajority vote on.
And supermajority meaning 60% of the voters have to vote yes or no for yes or no to work, or is it that 60% have to vote yes, and if they don't, it's just a no?
So 60% have to vote, or it's a no?
60% have to vote yes.
At least 60% have to vote yes.
I've always wondered that too. Is it 60% of registered voters or 60% of the number of voters who vote?
Well, I'm hoping that the people who vote in this election are registered voters.
No, what I mean is, like, let's say you have 1,000 registered voters,
Sure.
but only 500 of them vote, and the other 500 stay home, because we also know that 100% of voters don't vote.
That's a good question.
So is the 60% of the 500 who actually voted, or of the whole 1,000?
The way I understand it, it's the people who vote.
It's the people who vote. Okay, so it matters. It matters.
That's why, Rock the Vote and everybody's on every side. Somewhere, rappers and country stars, everybody's telling people to go out and vote. And I think that's one of the reasons.
Got it. Okay. Thank you so much for coming on here and answering this, because what you've said is what I'm encountering as well. There is a lot of misinformation. And the whole reason that I wanted to do this show is just to be very clear with what is true and what is not. What everybody decides to do with what is true is between them and their God, if they have one, if they worship one, and only they will know what they did with that information when they vote.
Rebecca, it's always a pleasure coming on here. What I can say is that most people that I encounter on a day-to-day basis, whether it be in my family, clients, friends, most of them are single-issue voters. And so what you can imagine, if abortion is your issue, what you're most either affected by or that it strikes you as something that is very important in society, my heart goes out to you, because I one way or the other, having an opinion on it, I think is important. Mm. However, forming those opinions based upon categorical and empirical evidence are very important. And so what you're doing here, I think, is of the utmost importance to our society.
Well, thank you for helping me do it. I appreciate it.
Anytime.
If you have questions about Amendment 4, maybe something your pastor said or you heard in a television ad or saw on social media that you want me to check out, my email address is in the episode description for you. Because here's the thing. When we are standing with that ballot in hand on November 5th, it is incumbent upon us not only that we know our values, but that we know how to vote in accordance with them. No one will know. No one is responsible for our vote, but each of us individually. Thank you for joining me on this journey so far. I'm really grateful to be on it with you.
You've been listening to Right to Life on the 1C Story Network. If you have a story to share or would like to learn more, please visit righttolifestories.com. This show is brought to you by the generous support of people who value life. To contribute, visit righttolifestories.com or get in touch.
The 1C Story Network, for the love of stories.